Welcome once again to Lehto's Law. Here's Steve Lehto.
Kenneth sent me a note about a case out of New Jersey. And this is an interesting case, and this would only be the situation in New Jersey with respect to who could rely upon this court ruling. But the New Jersey Supreme Court has upheld privacy rights with respect to a warrantless police search of a car. The police searched a car without a warrant, and what they found was thrown out of court because the Supreme Court of New Jersey said, you should have got a warrant. And so we've heard of many situations where the police at the roadside find themselves digging through someone's car without a warrant. And then what they find will get the driver in trouble or the owner of the car or whatever it might be. And the question is, should they have gotten a warrant in those cases? So from the New Jersey Monitor, this story is written by Dana D. Filippo. Police stopping motorists to investigate crimes cannot search their cars without a warrant unless the circumstances that sparked their suspicion were unforeseeable and spontaneous. The New Jersey Supreme Court ruled this past week. The justice who wrote the opinion cited New Jersey's Constitution as a reason for affirming the lower court rulings that suppressed the evidence found in a warrantless car search back in 21, as well as the Fourth Amendment to the U.S. Constitution. Now, this story actually says that New Jersey's Constitution provides greater protection against unreasonable searches and seizures. And I'm curious about that. They say compared to the Fourth Amendment, it's better. I will point out to you at the end of this story here that the two portions of the Constitutions read almost identically. In fact, the only thing that's different between them is largely the punctuation. The justice also cited precedential case law that allows police to forego a warrant only in unforeseeable and spontaneous circumstances. This case stemmed from the arrest of a man who Toms River police charged with various crimes after finding drugs and weapons and other things in his car. Officers have been surveilling him at a condominium complex back in August of 2021, 2 months after a resident reported illegal activity and a month after an informant told officers that there was a drug dealer known as Killer who drove a 2017 GMC Terrain around there, according to the ruling. Now, we don't know if this informant was known as Huggy Bear or not, but it sounds like it. An officer had identified this man as having a prior drug record that included the Killer nickname as a suspect through criminal records. So an hour and a half after the officer first spotted the vehicle, the officers pulled the vehicle over, and they found that the man had no drugs on him and simply refused when the officer said, "Can we search your car?" And he said, No, I will not give you permission to search the car. Officers then called in a police canine who sniffed around outside the car and signaled the presence of drugs according to the ruling. Imagine that. They brought in a drug dog and he found drugs. So they said that established probable cause, but here's the thing. The court says the circumstances leading to that probable cause were not unforeseeable or spontaneous. The officers suspected criminal activity from the start and should have gotten a warrant. And I wish the court had said they should have got one because they could have got one. That is, they had plenty of time. The question really almost always is, would a judge have signed a warrant when confronted with the evidence these people had before they confronted the man? Okay? And so it says here, they should have gotten a warrant. And so if that much time was going to pass, they clearly had time to go get a warrant, but would a judge have signed off on it? That's the real question. And if a judge wouldn't have signed off on it, and they know it, that might be one of the reasons they didn't get one. So the fact that the canine sniff is what culminated in probable cause does not eviscerate the steps that led to it. The sniff did not exist in a vacuum, but rather served to confirm and provide evidentiary support for the investigators' suspicions. The canine sniff was just another step in a multi-step effort to gain access to the vehicle to search. After police searched his car without his consent or a warrant, they found drugs and weapons and so on. The man then admitted that those things belonged to him, according to ruling. But a trial court judge declared the evidence inadmissible because officers failed to get a search warrant. And here's the cool thing. People always say, Steve, you read these cases about appellate courts straightening out things lower courts did wrong. So it sounds like the lower courts are always screwing up. No, here the trial court got it right. The trial court threw the evidence out. So the prosecutors appealed that to a 3-judge appellate panel, which upheld the ruling. So the appellate court got it right also. And now the Supreme Court of New Jersey is getting it right again. So here we actually have the trifecta. That is, all 3 courts got this ruling right. Unfortunately, the prosecution just didn't want to take that as an answer. So in affirming those rulings, this court wrote, the investigative stop was deliberate, orchestrated, and wholly connected with the reason for the subsequent seizure of the evidence. A warrant was required before searching that vehicle. The court noted, though, that such debates are fact-sensitive and could be decided on a case-by-case basis. So in other words, if another identical set of facts comes up, except there's a different fact, that is the amount of time between when the police realize this person's a suspect, that might change it. So an attorney argued before the court on behalf of the criminal defense lawyers of New Jersey and noted that federal law is more expansive in allowing warrantless car searches, so he celebrated the ruling. This is a reaffirmation that the New Jersey Constitution protects individual rights and privacy. Prosecutors have been trying to return the state to the federal standard for years, but without really blinking, the Supreme Court stood by its view of how the state constitution applies to criminal law. In that respect, it's a very important decision. And again, that's referring to the state constitution. Meanwhile, the attorney who represented the man at the heart of this went to court Wednesday afternoon to request his release from prison, and a judge agreed to free him. He's been in prison on this case for over a year and a half, despite the fact the evidence was thrown out by the trial court, and that decision was upheld by the Court of Appeals and now the Supreme Court. I do certainly anticipate the state will be dismissing these charges, the attorney said. This is obviously a great victory for the privacy rights of motorists in the state of New Jersey. Now, the Fourth Amendment says, and I'm going to read it to you verbatim, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Article 1, number 7 of the New Jersey Constitution says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue except upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the papers and things to be seized. Those are almost word for word exactly the same. One of them has a semicolon after violated, when the other one has a comma. The amendment to the Constitution of the U.S. actually has some of the nouns capitalized, which was the style back then, but not all. The U.S. Constitution says, particularly describing the place to be searched and the persons or things to be seized. And New Jersey says, particularly describing the place to be searched and the papers and things to be seized. So other than that distinction, where the U.S. Constitution, Fourth Amendment, talks about a person being seized in this section, New Jersey just says, and the papers and things to be seized. So that's the only distinction between those two sections. And every article I saw on this, and I read several because I was trying to figure out what they're getting at, said specifically that New Jersey's Constitution provides greater protection against unreasonable searches and seizures than the Fourth Amendment. And so I'm not sure if there's another section of the Constitution in New Jersey, because I went and looked and I couldn't find anything on point. But theirs is structured a little differently than the U.S. Constitution. So I'm not sure where it might be hidden if there's another section that is better than this. It also very well could simply be that the courts of New Jersey have interpreted this differently than the Supreme Court and the district courts in the U.S. on federal questions. That's possible also. But I agree with this ruling, and I've mentioned this before, that when you hear about the police seizing something or somebody without a warrant, there are a lot of exceptions that allow them to do that. So I can give you the best example is, let's suppose a police officer is driving along in his car and he witnesses a crime take place. He sees it with his own eyes, okay? And he can then walk up and arrest the perpetrator of the crime without getting a warrant. And that would be one of the exceptions. Now, he can go and do whatever he needs to do afterwards, but when he says, I witnessed the crime taking place and I actually walked up and stopped the crime from taking place or stopped the criminal in his criminal action and made the arrest right then and there, you're not going to say, oh, I'm witnessing a crime, I got to go find a judge quick. No, and everyone understands that. But when there's a situation where the police are watching a guy and they think that he's committed some crimes, and they think he's got some stuff in his car, and they've been watching him for a while. Now, a while could be, as you know, a vague term. But the point is, was the while long enough for them to go get a warrant? Because they can get a warrant surprisingly fast. They can. And so the question is, if they could have, why didn't they? And I would argue that many of the cases I've read, the reason they didn't go get a warrant was they feared that they couldn't get one. So they walk up to a judge, figuratively speaking, and they have an affidavit requesting a warrant. They go, here's what we got. An informant told us there's a guy named Killer, and he's breaking the law. And we've done some investigation, and we discovered that the man's name is this, and people call him Killer. Can we get a warrant to search his car? Based on an informant telling you that the guy's breaking the law. Anything else? That's it? That's all you got. An informant has told you this guy's breaking the law and his nickname is Killer. And we've confirmed, because that's the part they confirmed. They confirmed that there was a guy named Killer. That's the name he's known by on the streets. It's like Huggy Bear. It's not a God-given name on your birth certificate. It's actually the name that they call you on the streets. So it's an interesting story. It's fascinating. But as the court points out, it'll depend on a case-by-case basis. So, like I said, there's that period of time where they could have gotten a warrant. What happens if that gets shortened and shortened and shortened? And somewhere in there's going to be the line where they're going to say they didn't have time to get one and they had enough going for them to where they can say that they had cause to do that without a warrant at that time. So it's a great case. Kenneth, thanks for sending it to me. New Jersey Monitor says, New Jersey Supreme Court upholds privacy rights in warrantless police searches of cars. And Dana D. Filippo wrote that. And keep in mind that that is the Supreme Court saying that in this case, they could have got a warrant, they should have got a warrant, but they didn't. Questions or comments? Put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Sunsets are proof that endings can be beautiful too.